So the attempt to establish a legislative fence around a social evil does not help or assist the forces that maintain the social evil, whether that force is a court edict or, say, majority rule, which in the particular circumstance may require a social evil that's existing. And I think fences have a number of different benefits, and I count at least 8 to 10 in the context of the abortion issue specifically. If you look back over the last 35 years since Roe versus Wade, legislative fences around abortion have limited the abortion license. They kind of fenced in the abortion license, kept it from expanding. They have demonstrated the breadth of Roe versus Wade, that it just doesn't legalize abortion in the first trimester, but has legalized abortion up to birth. Bills are effective means of state and national education. You wouldn't know about partial birth abortion without the federal bill on partial birth abortion. Fourth, abortion has been the subject of elections precisely because it's been made a legislative issue. Elections are fought over what happens in the legislature. Elections are fought over policy issues. So you have to make a moral issue a policy issue to get it the focus of elections. Fifth, it's important to have the sanction of law approved by public opinion and the system of representative government behind any moral proposition. It's one thing to make a moral proposition in the public. It's something in addition to make it to give it the sanction of law through representative government and our system. In addition, these fences around the abortion license have certainly reduced the incidence of abortion. Again, abortions have dropped 25% since 1992. They have helped to bring about gradual change. They've put into place a broader legal foundation that was even in effect before Roe versus Wade. Those 36 fetal homicide laws that I mentioned were not in effect in the states before 1973. And it has certainly kept the issue alive that wouldn't have happened just by, say, picketing or public education alone. Not to say that those aren't important, but it's important in addition to those to have the sanction of law behind a moral proposition. Now, you've perhaps heard it claimed that this dilemma, attempting to limit unjust laws while unable to prohibit or overturn them outright, is a question of moral compromise. That term is often used when this dilemma arises. But on close examination, it seems to me that this claim just doesn't make any sense whatsoever. In its briefest definition, compromise means mutual concession. That was, for example, Lincoln's understanding of compromise. He once described the Missouri Compromise of 1820 as, he said, at length a compromise was made in which, like all compromises, both sides yielded something. So compromise assumes kind of an even distribution of power between two sides who each give up something in order to strike a settlement. So, for example, the Oxford English Dictionary defines compromise as, quote, a coming to terms or arrangement of a dispute by concessions on both sides, a partial surrender of one's position for the sake of coming to terms or reaching a settlement. That's what compromise means. So because compromise involves mutual concession, we would reject the term compromise if applied to a situation in which a person's will is overpowered by the will of another person or by a group or by a court or a legislative majority. And so no one would refer to a woman raped by a man or a group of soldiers who retreat in the face of a superior force or a person who gives up their wallet at the point of a gun as having compromised. Because we understand that people in such situations are defeated by a counter and overwhelming force. And we hold responsible not the person who was the victim, but whoever defeated the weaker person with that overwhelming force. And I suggest that this is a metaphor, an analogy for the situation where legislators seek to establish a legislative fence around a social evil when they cannot eliminate it entirely due to legal or political obstacles that are simply beyond their control. And being blocked from achieving more in the legislative or political arena by courts or majority votes or majority public opinion is not a concession or a compromise. Now, thankfully, we don't have to worry that we're the first generation to encounter these prudential challenges. I could cite dozens of examples of political leaders whose prudence or imprudence that could instruct us. Winston Churchill, when he became Prime Minister in England in 1940. Nelson Mandela in South Africa between the late 80s and 1994. Margaret Thatcher in England. All of these examples would be instructive. But let me just emphasize three briefly tonight. Those three are the Federalist Papers, William Wilberforce and his allies in the 1780s, and Abraham Lincoln and the Whigs and the Republicans in the 1840s and 50s. The American founders were committed to natural rights and natural law. They were committed to the good. But the founders retailed their natural law and their ethics. As Michael Novak has said, the founders were not primarily metaphysicians, they were nation builders. The American founders did not contribute to history a unique ethical understanding of prudence, but their exercise of political prudence in creating independent colonies, new state constitutional governments, and a federal constitution was unprecedented and far-reaching. And it has had profound implications for the American political and legal system and for world history. And the founders' generation of understanding of virtue and political prudence really culminates in the Federalist Papers, written, as you know, by Hamilton, Madison, and Jay. And more than 2 centuries later, I think the Federalist Papers is really a national treasure in teaching political prudence. Because first and foremost, the Federalist is realistic about human nature. And because of its realism about human nature, that we have a mixture of good and evil, that we are fallen, the Federalist seeks to explain the prudential arrangements struck in the proposed Constitution and why government itself is needed to control. You remember Madison's famous statement, I think it was in Federalist 51, in which he says the challenge is how government can control the governed and how the governed can control the government. A second implication of prudence in the Federalists was establishing a system of government that both preserved liberty and prevented tyranny by controlling and balancing power. This was perhaps the greatest challenge of prudence in the founding generation. And to do this, the founders carefully designed political structures. These included limited government and republicanism and a mixed constitution and a separation of governmental powers, checks and balances, and then with the Constitution of 1787, federalism. So if you want to understand why Roe versus Wade has survived for 35 years, I think there are 2 primary reasons. One is the governmental structures diffuse political power by design, by the intent of the founders. We have 2 systems of government. We got a federalist system. We have a national government. We have state governments. And within both levels of government, we have the separation of powers, which diffuses political power so as to prevent tyranny and preserve liberty. And I think secondly is certainly support for Roe versus Wade from strong cultural, social, and political institutions like the Democratic Party and the AMA and the ABA and the Legal Academy. These have strongly supported Roe versus Wade from a cultural and political perspective.